In this video, we'll discuss about administrative functions and as it is being defined in certain leading cases. So, in the leading case, Ram Jayesh versus State of Punjab in 1955, it was defined as the residue of governmental powers and functions that remain after legislative and judicial powers and functions. So, also in the leading case, Jayant Lal, Amrit Lal versus F.N. Rana in 1964, it was defined as orders passed usually based on the policy of the government, not bound by the rules of evidence and procedure unless the relevant statute specifically imposes such obligation. It may delegate and subdelegate such powers and functions unless there is specific prohibition in the relevant statute. And in the leading case, Maneka Gandhi versus Union of India, it was as defined. Article 14 prevents discretionary powers and functioning vested in the executive. The statute which confers such powers and functions should lay down some guidelines and principles. Ministerial functions are making decisions, issue of orders, and execution of acts. These are quasi legislative powers and functions in the form of delegated legislation or to make subordinate legislation to supplement the main legislation. It is due to the increase of the business of legislation, technically of the subject matter of legislation, emerging situations requiring quick actions, the need of modification in law according to local needs and conditions, etc. And Salman has classified it as subordinate legislation, which constitutes as colonial, executive, judicial, municipal, and autonomous bodies. So also the ordinance making powers of the president and governors are falling under administrative functions. These are otherwise rules, regulations, bylaws, notifications, circulars, orders, etc. And regarding quasi-judicial functions, acts or functions has some trapping of judicial nature. These functions of administrative authorities are required to be made subject to the principle of natural justice and the writ of certiorari. In Rex versus Electricity Commissioner in 1924, the King's Bench, and in Radhesham versus State of UP in 1959, it was expressed that a quasi-judicial body or authority may be taken to mean the body or authority to determine the question which affect the rights of the subject and having duty to act judicially. And the Donoghmore Committee in England, as constituted by the House of Commons on Ministers' power, expressed the view that a quasi-judicial function presupposes an existing dispute between two or more parties on a question of fact, evidenced by the parties with assistance of argument on behalf of the parties, but does not necessarily involve a question of law. It involves the adjudication by the administrative body or authority, the function of the industrial tribunal under the Industrial Dispute Act may be mentioned as an example of quasi-judicial function. The authority has to act judicially. The principle of natural justice, a body to be quasi-judicial will have legal authority to determine questions affecting the rights of the subject, and it is under duty to act judicially. The Supreme Court has made it clear that the test for administrative act is whether the statute has expressly or impliedly imposed upon the statutory body a duty to act judicially and to observe the principles of natural justice. So, in Dwarkanath versus ITO in 1966, the Supreme Court observed that the body has to take account of the nature of right affected, the manner of disposal, provided the objective criteria to be the adopted the nature of power conferred and the nature of duty imposed or on the authority. So, in the leading case, R versus Legislative Committee of the Church Assembly in 1928, the King's Bench, under Chief Justice Lord Heward, expressed the body should have both the legal authority and to act judicially. In both high school versus Ghanshyam in 1964, the Supreme Court also expressed the same view. Thus, on the function is held to be quasi-judicial or any act if there is a dispute between two or more parties and the authority is required to adjudicate upon the dispute. So also, in the leading case, Bharat Bank versus employees of Bharat Bank in 1950, and also in Hari Nagar Sugar Mills versus Shyam Sundar in 1964, Supreme Court held that the power of the central government under Section 111 of the Companies Act 1956 is quasi-judicial. So, also in Sri Bhagavan versus Ramchandra in 1965, the Supreme Court held that giving of concurrence by the administrative authorities for filing a suit for eviction by the landlord against his tenant on grounds other than those specified by the statute was to be quasi-judicial. So in K. Kariapak versus Union of India in 1970s, it was held as in determination whether a power is administrative or quasi-judicial, one has to look to the nature of the power conferred, the person or persons on whom it is conferring that power, the consequences and the manner of exercising that power. So, the dividing line between an administrative power and a quasi-judicial power is quite thin and is being gradually obliterated as it involves civil consequences. It is required to be met consistently with the principles of natural justice. So, in D.K. Jadhav versus GM Industries Limited in 1993, the civil consequences as expressed in the decision includes not only infringement of property or personal rights but also civil liberties and non-pecuniary damages. Also, in the leading case, M.S. Gill versus Chief Election Commissioner in 1978, it was held everything that affects a citizen is civil life. It, his civil life involves is civil consequences and ambit of the principle of natural justice has been extended even to pure administrative or executive functions, and the very concept of fairness. Also, in the leading case, Swadeshi Cotton Mills versus Union of India in 1981, it was held the same opinion by the Supreme Court, and in Delhi Transport Corporation DTC Mazdoor Congress in 1991 and also in D.K. Jadhav case in 1993, the Supreme Court held that OD alterum partem and Article 14 is applicable to both quasi-judicial powers and also to administrative orders. And in the leading case, Neelam Misra versus Harindra Kaur Pantal in 1990, it was held that administrative action, whether legislative, or administrative or quasi-judicial must not be illegal, irrational, otherwise it would be against Article 14. So also there is the requirement of fairness in action, whether it is administrative, quasi-judicial or judicial. In case of quasi-judicial functions, the authority is to act judicially, but in case of administrative functions, it depends mainly on administrative discretion of the administrative authority. Disciplinary proceedings against the students, cancellation of examination results of students for using unfair means, dismissal of employees on ground of their misconduct, and forfeiture of personal gratuity are some instances of quasi judicial functions. The order for setting of inquiry commission and the power of authority to issue license have been held to be administrative functions. The quasi-judicial functions differ from judicial functions. Quasi-judicial functions has some trappings of judicial functions and not all of them. Thus, judicial actions are exercised by the regular courts, while quasi-judicial functions is exercised by the administrative bodies or authorities. A court is bound by the rules of procedure and evidence, but quasi judicial authority is not bound by them. Thus, the court is bound to follow the Civil Procedure Code or Criminal Procedure Code or Indian Evidence Act, but the quasi judicial authority is not bound by them. A court is bound by precedents, but quasi judicial authority is not bound by the precedents. So, these are the very differences we found between administrative function and judicial functions, and also the difference between judicial functions and quasi judicial functions. So, as while administrative functions are purely those functions which are as decides and those rules, regulations, circulars, notifications, bylaws, and while the very adjudicating functions of those quasi judicial bodies like the administrative tribunals are considered as quasi judicial functions, where exactly the very quasi judicial body is not bound to follow the procedural law and also the Evidence Act, as well the regular courts which are considered as judicial bodies. They are bound to follow the Civil Procedure Code, the Criminal Procedure Code, so also the Indian Evidence Act, as, as also regarding the very nature of precedents, and regarding that the regular courts are bound to follow the precedents, as while the quasi judicial authorities are not bound to follow precedents. So, in our upcoming video, we will discuss regarding administrative tribunals.